Welcome to the Supreme Court of the United Kingdom. The Supreme Court hands down judgment this morning in the case of Matthew and others, appellants, against Sedman and others, respondents. This is a brief summary of the court's reasoning. The appeal raises a question of law in relation to the calculation of limitation periods. The issue is whether, where a cause of action accrues at or on the expiry of the midnight hour at the end of a day, the following day counts towards the calculation of the limitation period. The appellants are the current trustees of a trust, having replaced the respondents who were the previous trustees. The trust, as a consequence of holding shares in a company, had a claim under a court-sanctioned scheme of arrangement between the company and its creditors. A valid claim in the scheme of arrangement could only be made up to midnight at the end of the day on Thursday, 2nd June 2011. The respondents, who were then trustees of the trust, did not make a claim in the scheme of arrangement on or before that date. Some 6 years later, the appellants commenced proceedings against the respondent based on their failure to make a claim in the scheme of arrangement on or before the deadline. These proceedings were commenced on a date which made it crucial to determine whether Friday, 3rd June 2011, the day which commenced immediately after the expiry of the midnight deadline for bringing a claim, counts towards the calculation of the 6-year limitation period. If Friday, 3rd June 2011 is included, the limitation period expired 6 years later at the end of Friday, 2nd June 2017. In that case, the proceedings were brought outside the 6-year limitation period and are statute barred. If Friday, 3rd June 2011 is excluded, then the proceedings were brought within the 6-year limitation period and are not statute barred. The Court of Appeal held that Friday, 3rd June 2011 should be included in the calculation. It accepted that in cases where a cause of action accrues partway through a day, that day is ignored in the calculation of time for limitation purposes. But a different rule applies where the cause of action accrues at, not after midnight. In a midnight deadline case, the day following the expiry of the midnight deadline should be included for limitation periods purposes, as it is a whole day. The proceedings were therefore brought out of time. The appellants appeal to the Supreme Court, contending that the cause of action accrued on Friday, 3rd June 2011, and that the day on which a cause of action accrues should be excluded from the calculation of a limitation period. The Supreme Court unanimously dismisses the appeal for the reasons set out in a judgment given by myself, with which the other justices agree, which reasons I will now briefly summarize. The reason for the general rule that the day of accrual of the cause of action should be excluded from the reckoning of time is that the law rejects a fraction of a day. The justification for that rule is straightforward. It is intended to prevent part of a day being counted as a whole day for the purposes of a limitation, thereby prejudicing the claimant and interfering with the time period stipulated in the Limitation Act 1980. However, In a midnight deadline case, even if the cause of action accrued at the very start of the day following midnight, that day was, for practical purposes, a complete undivided day. Realistically, there is no fraction of a day. The justification in relation to fractions of a day, therefore, does not apply in a midnight deadline case. The effect of excluding a full undivided day in a midnight deadline case from the calculation of time would be to give the claimant the benefit of a limitation period of 6 years and 1 complete day. That would distort the 6-year limitation period laid down by Parliament and would prejudice the defendant by lengthening the statutory limitation period by a complete day. Accordingly, here, because Friday, 3rd June 2011 was a whole day, it should be included in the calculation of the limitation period. The proceedings were therefore brought outside the 6-year limitation period and are statute barred. In a midnight deadline case, realistically, there is a complete undivided day following the expiry of the deadline, which should be included when calculating the limitation period. The appeal must therefore be dismissed. The court is now adjourned.